Hi, my name is Catherine Crace. I'm a lawyer, social worker, and researcher. I'm here today to talk to you about protecting client confidentiality, understanding and asserting therapist privilege. Let's start by understanding the difference between confidentiality and privilege. Psychotherapists have confidential relationships with their clients. Confidential relationships are one where the professional is ethically and or legally bound to keep information shared by their client with them in the therapeutic relationship private. But there are limitations to that obligation. When someone tries to access a therapist's records in order to use them in a court case, it might be appropriate for the therapist to assert privilege in order to continue to protect their client's confidentiality. Privilege is related to the confidential nature of the relationship between the therapist and the client. But privilege and confidentiality are not synonymous terms. Confidentiality relates to the responsibility of certain professionals, like therapists, to keep client information private. The ethical codes of social workers, psychologists, counselors, marriage and family therapists, and psychiatrists, for instance, all define the therapist's obligation to client confidentiality. Federal and state law also defines the therapist's obligation to client confidentiality. But law and ethics on client confidentiality also have limits. Privilege relates to the obligation of certain people, usually professionals, to protect certain information from being introduced during a legal proceeding. The protection provided by privilege derives from a confidential relationship. The protection of privilege can only be asserted in relation to a legal proceeding. There are 5 commonly recognized privileges: attorney-client privilege, doctor-patient privilege, clergy-penitent privilege, marital privilege, and therapist-client privilege. We're going to be talking today about therapist-client privilege. The United States Supreme Court, in the case of Jaffee versus Redmond, determined that all federal courts should recognize a therapist-client privilege, though even that privilege has limits. In Jaffee versus Redmond, a therapist asserted privilege to deny access to the records of a client. When the trial court refused to recognize therapist-client privilege, the therapist refused to hand over any records or answer any questions during their testimony, which was compelled by subpoena. The therapist's client appealed the trial court's denial to recognize the therapist-client privilege and ultimately won at the highest level, the United States Supreme Court. But there are limits to therapist-client privilege that are important for you to understand. Privilege is not absolute protection for client confidentiality in legal proceedings. First of all, in the Jaffee versus Redmond decision, the United States Supreme Court made it clear that therapist-client privilege applies to all different kinds of mental and behavioral health professionals as long as they are providing psychotherapeutic services to their clients in legal and ethical ways. Some state courts provide a larger protection of privilege. So it's important for therapists, whatever their profession, to understand that privilege might only protect communications provided by the client in therapy. If a mental or behavioral health professional is providing services other than therapy to the client, the privilege may not apply to those communications. It depends on the state and the context. Another limitation of privilege is a client release. If the client wants the therapist to share records with the court or testify, then the client essentially is releasing the privilege. In these situations, the therapist should ensure that the client understands what information would be shared if the release were to go into effect. It is recommended that the therapist require the client to sign a written release that outlines their understandings of what will be shared with the court. Mandated reporting is another limitation of privilege. Privilege doesn't stop a mandated reporter in any confidential relationship from legally and ethically making a report to CPS or Child Protective Services. However, mandated reporters in a confidential relationship with a client should only make reports to CPS when they are required. For support on making this determination, check out our mandated reporter guide and our other blog posts at www.makingthetoughcall.info. And the final limitation is the idea of best interests. Judges can do what we call pierce privilege and require a therapist to provide documentation or testimony of a confidential nature, but only in certain circumstances. For instance, a judge might pierce privilege of a treating therapist in a child maltreatment or custody proceeding. In those cases, the judge is required to make a judgment based on the best interests of the child. If the judge determines that the therapy records are necessary to make such a determination, they would require the submission of some records or testimony. In those circumstances, the therapist should do whatever they can to limit the amount of confidential information shared with the court. We call this safeguarding client confidentiality. If an attorney or judge asks or demands that a therapist disclose client confidential information that was obtained through psychotherapeutic service, the therapist should simply respond verbally and in writing where practicable that they refuse to share the information in recognition of therapist-client privilege. The therapist can also provide citations to their applicable professional codes. For information on the codes of social workers, psychologists, marriage and family therapists, counselors, and psychiatrists, check out the blog post on this particular subject at our website. If a judge insists that the therapist share information due to the best interest standard, the therapist should demand a written decision from the judge clarifying that they have essentially pierced the therapist's privilege for a specific purpose. The therapist should then insist that only records and testimony necessary to meet a specific legal purpose be shared with the court. For more information on the ethics of mental and behavioral health professionals, check out our other blogs and other information at www.makingthetoughcall.info.